Good day, Attorney Sai. Good day, everyone. Today, I will be discussing about the Labor Code of the Philippines, Presidential Decree Number 442 of 1974. I will be discussing the two topics. First is how the Department of Labor and Employment enforces the Labor Code and the use and implementation of the DOLE checklist. So, the Labor Code of the Philippines stands as the law governing employment practices and labor relations in the Philippines. It was enacted on Labor Day of 1974 by former President Ferdinand Marcos. This presidential decree played a huge role to what the employment world is today. Prior to 1974, there were laws about labor, but it was not well defined, unlike the labor code that is the grounds on general labor standards of the Department of Labor and Employment today. So, how does the Department of Labor and Employment enforces the labor code? It is written in the Book 5 of the Labor Code, which is about labor relations and divided into 9 titles: the Policy and Definitions, National Labor Relations Commission, Bureau of Labor Relations, labor organizations, coverage, unfair labor practices, the CBAs, the strikes and lockouts, and the special provisions. So the Labor Code of the Philippines has this what we call as the general labor standards, where it is defined on how much wage you should give your employees, what are the mandatory benefits that the employees are required to have. So those are written in the Labor Code of the Philippines. And if there are unfair labor practices, if those demands from the employees were not addressed, then this is the time where the complaints could be addressed to the Department of Labor and Employment. And one of the bureaus who handles the complaints is the Bureau of Labor Relations, which really plays a huge role in taking care of the side of the employees in labor disputes or labor complaints. So the Bureau of Labor Relations and the Labor Relations divisions in the regional office. So we need to understand that this is the enforcement arm of the Department of Labor and Employment in the provincial and regional offices, and they shall have the authority to act on their own initiative or upon request of either or both parties on all inter-union and intra-union conflicts. So this is how important the Bureau of Labor Relations is. Now, the tripartite industrial peace council, as defined, involves the promotion of tripartite industrial peace council's formation. So, the tripartite industrial peace council, as you can see, is a peace council which is composed of 3 entities. Namely, number one, of course, the Department of Labor and Employment, because this is the guiding principles, or the department, the government body who does the promulgation and the policy formulation on how to take care of the employees. And in the tripartite council, there is a representative for the workers, well, coming from the unions, and also the management, the employers, or the company that where these workers are connected. Now, labor organizations. Now, what are labor organizations? This refers to any union, whether from the public or the private sector. And this exists for collective bargaining, mutual aid, interest cooperation, and most especially the protection of employee rights and other lawful purposes. In other words, labor organizations provides the voice for the employees. They select a representative to address concerns if there are unfair or disputes. There were requests in the CBAs that were not answered by management of those companies that the workers are connected, or there are CBA agreements that the companies did not comply with. So these labor organizations plays a huge role as a representative in protecting the laws and the rights of every worker in a company. Now, there are two types. Of course, the public sector union. These are the employees that works for the government organization, and the private sector union, which works for the private sector organizations. And as you can see in this data, as of second quarter of 2020, there are a total of 493,000 members for public sector labor organizations, and there are a total of 1.5 million members for the private sector labor organizations. So you can see the distribution that there are really a lot of labor organizations in the private sector compared to the public ones. So what is a collective bargaining agreement? Now, the collective bargaining agreement refers to the negotiated contract between a legitimate labor organization, meaning it is registered, and the employer concerning wages, hours of work, and all other terms and conditions of employment in a bargaining unit. In other words, in a CBA, there are agreements that the management and the workers should meet together or should decide together. Now, in those agreements, of course, aside from what is due to employees, there will be a request, and those requests, just like the increase of minimum wage or whatever. So this should be addressed between the representatives of the union and, of course, the management of the companies where these workers are connected. This is very important because this will be used as the manual or the guiding words, guiding standards of the workers in order to defend their case, in order to present their case to the Bureau of Labor Relations. So as you can see in this next picture, um, it's here. These are rallies, no, strikes coming from employees from a manufacturing company, from a plantation, fruit plantation company, and as you can see, they are protesting for unfair labor practice, for the respect of the CBA, and of course, in requesting the management of the company to answer the CBA proposal. So this is what happens, and this is how powerful the CBA is. If there are CBAs that were requested from the movements, from the workers' movement, and management did not respond to those requests, then they could demand for the response of the request. And if there were unfair labor practices that were, that is practicing by or that is practiced by the company, and it is not written or it is not there in the CBA, well, they can also protest on those part because those are already violating the rights of the employees. So this is how important the CBA is, and this is for the employers or the employees unions. But when you enforce the labor code, and if there are labor disputes, these union organizations have what they call the grievance committee. So for example, if there's a conflict and they need to address the conflict, then they need to go to the union's grievance committee first. The management, where the workers are connected, and the representatives of the union would have to agree on something, would have to fix on something in addressing labor disputes. Now, if the conflict would not be addressed by the grievance committee of the unions, then you can they can escalate it to the higher court. And as you can see here, the distribution of CBAs for workers, it's really in the manufacturing side. This data, as provided from the Bureau of Labor Relations 2017, you can see that 47% are really in the manufacturing industry. This is where factories such as those fruit plantation factories and the likes have so many employees that have so many CBAs as well. And this is also happening. These are also the employees that have major concerns, especially in terms of workplaces, benefits, how they are treated. Now, if the grievance committee uh, from the previous slide was not able to address the conflicts between the management and the workers, then the Bureau of Labor Relations would endorse the conflict towards the National Conciliation and Mediation Board for the main purpose of interpreting the collective bargaining agreement. So this is the time that the NCMB would uh, would uh, would be part of the agreements, and they will perform conciliation and mediation functions, and they will also provide technical assistance in the preparation and administration of the CBAs and in drawing up joint agreements. So when the case or the conflict reaches the NCMB, uh, the NCMB is the bureau of the DOLE of the Department of Labor, which addresses the case and of course will also interpret the CBA. So of course, lawyers are here, and there are also a lot of people that are knowledgeable with laws on labor laws that are connected into this bureau of the Department of Labor. Of course, they also provide training on alternative dispute resolution. Now, if there are concerns that were not addressed in the NCMB, then the next step would be the National Labor Relations Commission. Now, this time, this has really the conflict has really reached the court. So the jurisdiction of the NLRC as an arbitration commission is to have exclusive jurisdiction to hear and decide within 30 calendar days. After the 30 calendar days, after the submission of the case by the parties for decisions without extension, both for workers in agricultural or non-agricultural companies. So if the conflict was not really addressed or was not the labor dispute was not fixed in the NCMB, then they can escalate the complaint to the NLRC. So this is already the court. So in summary, as you can see, all of these bureaus are under the Department of Labor and Employment as the executive department of our Philippine government mandated to formulate policies, implement programs and services. So if there is a conflict, then if it is in a union conflict, then they can present the conflict towards then the Bureau of Labor Relations will be the bureau that will be in charge in dealing with the conflict together with the help also of the representatives of unions. So as you can see, there are union representatives here, the Philippine Seafarers Union, and of course the KMP, Trade Union Congress of the Philippines. So these are just the example, few examples of the unions that we have here in the country. And if those cases will not be addressed, then the Bureau of Labor and Relations will endorse the case to the NCMB for the interpretation of the CBA. And if not, the case will still be there. The both parties do not agree on the terms and conditions that were presented to them, then the case will be forwarded to the NLRC for the proper or for the final judgment of a labor dispute. So this is how everything works because the NLRC is tasked to promote and maintain industrial peace based on social justice by resolving labor and management disputes involving local and overseas workers through compulsory arbitration and alternative modes of dispute resolution. So this is how everything works if the conflict will arise. Of course, this too is part of the collective bargaining agreement and it is enacted also under the labor code. Now, the use and implementation of the Department of Labor and Employment checklist. So, the one who enforces this checklist is the Bureau of Workers for Special Concerns. This bureau is the recognized government agency that champions the development and protection primarily of disadvantaged workers by contributing to their decent and productive employment. So if there are checklists that you need to follow as a company, then this is the bureau that is in charge of making sure that those companies are complying with the mandated changes. Like for example, the changes in minimum wage rate for a particular province, for a particular municipality. So this is the bureau who handles it. If these companies that are located in that area, in that city, are complying with the mandated changes in like for, particularly in wages. So this is one of the checklist of the Department of Labor and Employment, which this is a very precise checklist. You can see the name of the establishments, the respective representatives, and on the left side you can see also the entries for the general labor standards, the minimum wages, holiday pays, so on and so forth. And on the right side, you can see their findings if the company is complying or not. So, no, as you can see, they're shaded in gray. So, if they are not complying, then the Department of Labor and Employment has full authority, has the full right to file a case towards those companies, to those non-compliant companies. So one example for us was this wage order number RX 20 that was announced on 2018, 2 years ago. There were changes in the minimum wage amount for employees, particularly in Valencia and in Malaybalay City. So for non-agricultural employees, the old rate was 331 per day, but with this wage order, it was changed to 358. So as for us as a company, we are mandated to submit authority, and so we made a memo uh, addressing this request by this mandate from Dole, and after the memo, then we implemented the new wage for our minimum wage earning employees. So the main reason really is for according to the DOLE website about the labor inspection program, is to further strengthen the implementation of the visitorial enforcement of the labor code. So this is really for centered in the for protecting the rights of our employees. Make sure that they are also treated well and they receive the right benefits and wages as citizens also of this country. And the DOLE is a very um, employee friendly government body, and at the same time it's also fair on its judgment towards the employers. So that's it, and that is how the Department of Labor and Employment enforces the labor code and the use and implementation of the DOLE checklist. Thank you and God bless.